Void marriage. A void marriage is no marriage. It is a marriage that does not exist from its beginning. This is given under Section 11 of Hindu Marriage Act 1955. It is termed as a marriage because two persons undergo the ceremonies of marriage, but due to some incompetency, it is void. For example, if a brother and sister perform all the ceremonies of marriage and start living as a husband and wife, they will not become husband and wife in the eyes of the law even though they have performed the ceremonies and rituals of a marriage. Grounds of a void marriage, bigamy. It means either party has a spouse living at the time of the marriage. When the two parties are subinda to each other, when the parties are within the prohibited degree of relationship. The other two cases in which marriage is void are if proper ceremonies of marriage have not been performed and if a marriage has been performed in violation of the requirement of Section 15 of Hindu Marriage Act. Voidable marriage. A voidable marriage is a perfectly valid marriage so long as it is not avoided. It can be avoided only on the petition of one of the parties. This is given under Section 12 of the Hindu Marriage Act 1955. If one of the parties dies before the marriage is annulled, then no one can challenge the marriage. The marriage will remain valid forever. For example, suppose the husband is impotent and thus cannot consummate the marriage. Now, if the wife wants, she can continue being his wife and keep the marriage alive. It will just be like any other regular marriage. But if she likes, she can avoid the marriage and can file a petition in a competent court for the cancellation of marriage or to declare it as a void marriage. Grounds of a voidable marriage. Marriage not consummated due to the impotency of the respondent. Respondent is suffering from a mental disorder as to be unfit for marriage and procreation of children. The consent of the petitioner has been taken by fraud or force. That the respondent was pregnant by some other person other than the petitioner. The ground is the pre-marriage pregnancy of the wife and not her unchastity, relating to or engaging in a sexual activity, especially of an illicit or extramarital nature. The children born out of the void and voidable marriages are legitimate, and in no case the status of a child can be questioned.